Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Okay, good morning, everyone. Let me just quickly introduce the panel before we start the argument. To my right is Justice Peter Rubin. To my left is Justice Paul Smyth. My name is Ariane Vuono. I think you all know that you have 15 minutes to present your argument, and you surely also know that we've read everything that you've provided to us, so you can get right to your best points. I always have to remind everybody that there is no rebuttal in the appeals court, in case that's slipped anybody's mind. Today we're going to hear the first two cases and then take a brief pause so that we can set up a hybrid argument for case number 3. All right. This is Commonwealth versus David SILVIA, 2023-0379. Good morning.
Good morning. May it please the Court, Dana Curhan on behalf of David SILVIA. The first issue I want to address is the sufficiency of the evidence. We don't contest that the complainant was sexually abused when she was younger by somebody that she referred to as Unky. She testified that that happened when she was 5 or 6, and she did live with Sylvia and his wife when she was 3. And she did refer to him as Unky. However, she failed to identify him at trial. There was also no physical evidence corroborating that anything had happened and no corroborating evidence at the time. What ended up happening is her mother attempted to fill in some of the details by saying, well, the only person she referred to as Unky was Sylvia, not necessarily any of her other uncles or male adults. And I think that might be, if we were looking at a preponderance standard, maybe we would say that we've established his identity by a preponderance of the evidence, but as far as proof beyond a reasonable doubt, I think we fall short here.
Okay. As you well know, high bar in terms of looking at the evidence that we do have in the case most favorable to the Commonwealth. But basically, you're really isolating the element of identification.
Yeah, and that was the subject of the motions for required finding and not guilty. I mean, I don't think counsel contested that something had happened with somebody, and this little girl had been in various situations, and I think I don't think she had the. I don't think there was enough evidence establishing beyond a reasonable doubt that this defendant was the one who molested her. That's really my point. The second point, which I think is somewhat related, is that there was no competency hearing at trial. This was not objected to, but at the beginning of the complainant's testimony, she was asked, she was 9 years old at the time, she was asked if she could tell the difference between the truth and a lie. And, you know, she was a little vague, but I'd say she satisfied that prong. The problem is that the case law requires that there be some kind of inquiry or colloquy on the ability or inability to observe and recount what she was, what had happened to her. And nobody asked her any of those questions. The judge never made an inquiry. The judge never made a finding. She just sort of went on and she testified. And
what questions would you ask? I mean, I've never seen a voir dire about this, so what would you have had her be asked?
Well, probably, do you remember when you were living with him? Do you remember how old you were? Do you remember other details?
Didn't that all come out in her testimony?
Some of it did. I don't think a lot of it did. And the problem with her testimony is that she was vague about a lot of points. So, for example, she said that this happened when she was living with Unky. And she said that on direct. She said that at the beginning of her cross. And then she said that it happened when that Unky used to babysit for her, and she would be dropped off and picked up at the end of the day. Now, that wasn't happening she was just straight living with her aunt and uncle when she was 3. It raises the possibility that she's just not remembering, and maybe she's remembering a different situation where she had a babysitter. I mean,
I'm just trying to figure out why that's not a cross-examination or argument issue. You're saying the testimony has to be excluded, but she does recount some details. Just take, for example, the closing the dog in the bathroom detail. She does recount some details. I'm just trying to figure out what I mean, if you think that isn't enough, you see what I mean? I mean, I'm trying to think what the ability to relate events when she was there, and she does. She may do it wrong, she may be confused, but she does relate some events when she was there. How could a judge find that she can't?
well, she does, but it's not necessarily important details. Yes, when she was staying with her aunt and uncle, there was a dog. There may have been 2 dogs. She described a medium-sized dog. It's actually a small terrier and possibly another dog. But that doesn't tell you that that's where she was abused. It's a detail, and maybe...
Wait. So I'm just trying to figure out, obviously there are child witnesses a lot, and I agree with your general proposition. If they can't remember and relate what happened at the time, they're useless witnesses, or worse, obviously, they could be prejudicial, terribly prejudicial, without a good basis. But I'm just trying to figure out, surely we don't voir dire a child and make sure that every detail of 6 years ago is right. We wouldn't do that with a grown-up. So I'm just trying to figure out, how good are you saying her recollection and ability to, she certainly is relating something, and some of it seems to be based on accurate memory. So does it have to be better than that?
I think it does when she is 9 years old at the time of trial and 3 years old at the time of the incident. And by the way, her mother said she suffers from PTSD and ADHD, and it wasn't until she recently went on medication that she could actually focus on things. And, you know, what impact does that have?
Okay, but you're not saying you were entitled to bring an expert in on ADHD and memory. I mean, I don't know the answers to those questions. They're perfectly good questions. But I'm just trying to figure out what a judge is supposed to do before allowing a child witness to take the stand. I mean, look, we could have a rule, which of course we don't have, and I don't think it would be a good rule. No one under 5 can testify, or no one can testify about events that occurred when they were 4 or younger, but that's not our rule.
It's not our rule, and, you know, the concern is that there's a possibility that you had accurate details interspersed with inaccurate details, and there was no real colloquy. And again, I think the case law requires a colloquy.
But how is the judge supposed to determine what are the accurate ones and what are not? Let's say the whole thing with Unky is inaccurate. But if the judge does a voir dire and says, what do you remember? And she says, I remember the dog, I remember Unky, I remember this terrible event, and so on. Wouldn't the judge say, okay, now testify? I mean, you might say, but she's wrong about that. And he'd say, that's why we're having a trial, right? Or she.
I mean, I don't know. I can't tell you exactly what the judge should have asked. I know that that this sort of the general subject about her ability to recall, her ability to sort of process this and render it back accurately, there's some real questions about that.
Well, let me interrupt for a second, if I may.
Of course.
Of course, there are questions, but that really is, as Justice Rubin is pointing out, subject for cross-examination. When we talk about competency, aren't we really talking about not necessarily recalling events, but do you know the difference between a truth and a lie? That's generally what the subject matter is in terms of trying to determine if a child witness is competent. In this case, the prosecutor did ask some questions along those lines. But as I understand your point is, there should have been a more deeper inquiry by the judge before, to determine that, before the child could testify. Is that right?
Well, I don't think it's necessarily right and wrong. There's the SJC and this court have said there's a two-part test. You do ability to recall and et cetera, the ability to accurately describe what happened, recall the events and relate them to the court. Then the second part is truth versus a lie.
So
And-
are you saying that on both prongs are not satisfied here?
The second prong, I think, was.
Oh, you do? Okay, well then.
It was. She was 9 years old, and she was a little vague, but I think realistically, I mean, her description is adequate to.
Okay, all right.
The problem is that she's 9 years old and she's testifying to things that happened, 6 years earlier, and I think that's problematic. I think you have to, if she was 9 and was talking about something that happened when she was 6 or 7, maybe you don't have to do that. You probably should, but maybe you
Do
don't.
you think it makes any difference that this is a jury waived trial?
I don't think it makes a big difference. I think there's got to be that threshold inquiry, and because the finder of fact is a finder of fact. And if the judge, on the record, does the inquiry and makes a finding that she's not competent to testify to what happened when she was 3, then I don't think it makes a difference whether it's a jury or a judge. So that really is my point. I think the case law requires that two-part inquiry, and only one part was explored by the DA. There are no findings. The judge doesn't say, I find that this witness is competent. Unfortunately, we're under a substantial risk of miscarriage of justice standard, but I think we meet that.
Well, that's just it. The case law requires the two prongs as you're stating, but that's when it's an issue, a live issue. This wasn't raised to the court, correct?
It wasn't raised. It was raised in the motion for new trial, but it wasn't raised at trial.
At trial.
I mean,
So it's not required if it's not raised.
Well, I think it is. I think whenever you have a witness that young, if you have a witness who's describing events that happen at age 3, I don't see a scenario where the judge is not going to do this competency inquiry. And that really, I think the judge really should have stepped up and done this. The final issue involves first complaint. There were a couple of things that went beyond the scope of proper first complaint. One of them was the complainant's mother said she described hand gestures, and also there was a statement that was related. Oh yeah, she said that Unky said not to tell Auntie what happened, and this was a pretty close trial. In a case where the evidence was overwhelming, it may not have made a difference, but I suggest that it made a difference here. Unless there are any further questions, I will leave the remaining points to the brief. Thank you.
Thank you very much.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. To start with the competency issue, I agree with my brother counsel that there's two prongs to competency if it's raised, that in the absence of objection, a judge does not need to inquire. There's ability to understand truth versus falsehood, and there's whether the witness has the general ability or capacity to observe, remember, and give expression to that which she has seen, heard, or experienced. And my understanding is that that's not, based on the case laws, that's not of the charged offense, though I think we could meet that too, but that it's, is this person in touch with reality? Are they a percipient witness who can actually see? So that in past cases, asking a child, what is your religion? How old are you? Those sorts of questions do satisfy that.
How does that have anything to do with whether they could recall at the time that the event happened? I mean, a kid who's 9 might know their religion, but if you ask them But that doesn't mean that they knew what it was when they were 3.
Well, in terms of just, what the standard in the case law is about competency, though, I think that could be an interesting question, but that is not what this is aimed at.
Oh, wait. So you two are disagreeing about whether the second prong is about ability to recall and do things now, or when the child was actually going through the events. I thought the phrase had something to do with going through the events.
Well, I mean, I think that in this case, there is evidence of both.
Okay, but I'm asking what the
Yes.
test is.
Yes, my read on the test from the cases that have dealt with it is that I don't know if it squarely says that, sorry, I'm getting lost in my own notes.
Whether when they were 3, they had the
Whether
ability
they
to
were 3.
observe and...
I mean, so there is case law that said, that the prosecutor has established this basic competency by the fact that they know things about their current life. And there's also cases
Were people
where they looked at-
testifying about many years before when they were children?
I mean, these are all mostly child witness cases. I mean, it's the same test for an adult and for a child.
Of course, but the fact that a 50-year-old can remember when they were 43
Yeah.
is no surprise. It's only when we get into a
Yeah.
2-year-old, a 3-year-old, that it begins to be an issue, right?
All I'm saying is that is my reading of the test, and there are transcripts that say, you can also look at the rest of, at the action. So there are transcripts, there are cases where it was objected to, and there's a specific competency hearing, and but in terms of looking, they say you can also, even when that's true, you can look at the trial and look at the kid's testimony, and essentially, does it show ability to recollect? But essentially, it's something like, it wasn't wholly implausible or something like that. It's not, I mean, you can.
So I'm trying to figure out if a child comes in and is prepared to testify about something that happened when they were 2.
Mm-hmm.
I don't know if you can remember anything from when you were 2. I feel pretty strongly that I can't. And I don't know when you lose that. I suppose you would have remembered it the next day, maybe, but I have no idea. So the child comes in, they're 2. They're 9 now, but they were 2 when something happened. And they say, oh, I'll tell you all the details about it. Is that permissible without trying to figure out whether they are able to remember?
Well, again, I think there's two different, would it be good to have that policy? Is it fodder for something else? And is it the specific competency test we're discussing here, which my reading of the existing case law is?
Well, let me ask you this.
Let's
take the competency test away.
All right.
Can a judge allow a 2-year-old to testify? I don't know if we have, someone
Yeah.
who was 2, I don't know if I've ever seen a case like that.
Yeah, I mean, I think 2 versus 3, it probably changes more.
And under what rubric would
Yeah.
they exclude the testimony?
That I don't know. I mean, I know that there are, so the child first of all, has to say that they remember it all. But there's, yeah, I mean, I think, I don't have a direct answer for that particular question, being sort of focused on this particular case. I agree, it's an interesting, I suspect there's an answer.
Your brother says this is that case, so that's why I'm asking you.
Yes, no, I know, and as I said, I read the law differently, but I also, on the facts of this case, I feel like it would meet, as I argue, that it would satisfy either reading of the test, and therefore.
How would it satisfy the reading that she could recall things when she was 3?
Well, there is no, as a matter of law in general, there is no bar that a child is assumed not to be able to recall, and she gave a variety of details that sound, frankly, as I argued, that they come from a child's memory rather than from something somebody told her, some of which, like the dog in the bathroom, are very specific, some of which there are other things that she was wrong about. There have been one case I cite in my brief, Tybalt, I think, where the child had, she said a variety of things that were not accurate, but they said we do not, and they essentially, I mean, in that case also with the truth and a lie, I think she gave mixed answers about actually the color of the prosecutor's shirt, but they said if you sort of drill down, it becomes clear that she is understanding this and she does get it. You don't turn on any one particular answer.
What case is this?
Tybalt, it's 77 Mass Appeals Court. My site was 423 to 428. But they said we do not view the disparities in her answers to be so frequent or so severe as to show that her testimony in its entirety was beyond reasonable belief by a rational person, and that the first prong of the competency test does not hold witnesses to a standard of strict consistency, but rather requires of them a general ability or capacity to observe, remember, and give expression to that which she has seen, heard, or experienced.
But they don't talk about the second prong.
They do, but I didn't quote it for, the first, they also talk about the truth versus lie prong, but I didn't excerpt that in my brief because
Okay, I
it was
mean,
not.
everyone seems to agree that the first prong is met.
I think we agree the second prong is the truth versus lie, and I think that's what we're not disputing.
Okay.
I know. The second prong comes up more often.
Yeah, okay, I thought that was, all right,
Yes,
either way.
but, that's, so again, so my ultimate argument would be that, well, first of all, the judge said there was no issue with competency at the motion for new trial. There case law saying that with child witnesses, so much can turn on demeanor that there's a strong principle of deference to trial judges on that for having seen the person at all. And I would argue she had the information to form that opinion based on both the initial starter questions from the prosecutor, but also from the substance of the witness's testimony, and all of that would factor into this court's determination regarding ultimately whether there was an issue of competency under any of the things discussed in this case. And I agree it's an interesting area of law, but there aren't a ton of cases on. On the issue of identity, I cite Commonwealth versus Coates, which dealt with a broadly similar issue where there was dispute by the defendant about who was the named person that the complainant said had done the thing, and essentially that the complainant was clearly describing a particular person based on circumstances in life, and I would say that that is true here. Whether or not you argue that the jury should have believed her, it was clear that she was talking about this identifiable family and this identifiable person having done this. My understanding of the defense at trial was essentially that the mother had a lot of animosity and had set this up rather than, so they certainly argued the issue of identity being insufficiently proven, but I believe the complainant said he's the only one she called Unky. The mother said it, and also, again, she described, she may have given a different age for when she was there and not been clear on whether she was living there or not, but she described Unky and Auntie works at the restaurant, and there's the dog in the bathroom, and all of those, in that context, Coates also had an issue of inability to identify the defendant in the courtroom after some period of time, and said that that was essentially reasonable to send to the jury, given I think there was also evidence there that the defendant had changed appearance somewhat. Again, that's a jury issue, but.
Can I ask you briefly about the final argument about the scope of first complaint? I was surprised because the cases look to me like they go in two different directions. I had thought you're allowed to just tell what the first complaint was. I didn't know it had a scope. I understand there are some things you can't say, and I called the police and they can't, right? It's got to be about, but I don't understand. Is there a rule limiting the scope of first complaint testimony, or you just tell the details of the complaint?
So yes, there is, but it is, I managed to confuse myself on this rereading the case I rely on, which seems fairly clear on the facts of that case, which were pretty extreme. I know there are circumstances where you can go problematically outside the scope of the complaint.
What are those circumstances?
I can't tell you standing here what the line is. I cite a case where the details outside the scope of the complaint were, I would argue, much stronger than here. But
had anyone raised scope of the complaint, or that's not really what it was about?
That wasn't real. There was not any. There was an objection to identity of the first complaint witness, but there were not specific objections to any particular item of first complaint.
So when the court really addresses scope, they say there's a limitation. but they are approving lots of first complaint testimony in cases where it isn't raised that is clearly beyond the scope. Is that?
At least in this one case, and I mean, I don't know, maybe if we talked to Justice Sikora, he would say, well, that was based on something specific, but just based on my read of what I was, again.
He doesn't get to tell us.
He doesn't get to tell you, but I'm just saying that is, you know, when cases seem irreconcilable, and I didn't do a deep dive into exactly, again, how that, you know, it's one of those things, if I had another hour of prep, I would have looked into it. It occurred to me at the last minute, but essentially that there is case law that, you know, I would argue would apply here. And again, as I argue, ultimately, that the complainant, one could view the complainant as being a more readily credible witness for a variety of reasons than the mother, who the defense was able to elicit information to use in the service of arguing that she had bias, and actually, I mean, got her to volunteer that the victim had been shown her forensic interview every time she met with the DA, which is not clear that she would have had any way of knowing if that were true. So the defense was able to impeach her considerably and suggest that she had motive to want to exaggerate the testimony. So I don't know that in this particular case that anything that she said, the complainant said that the complainant didn't say, the jury would necessarily be like, well, that must be true because it was the mother, where the defense was that the mother put her up to it. And thus, presumably, the mother would, if you believed that, if you were inclined to believe that, you would not view the mother as confirming the truth of the complainant's testimony, as opposed to somewhat the other way around in this. I mean, obviously, it's relevant that there was a complaint, but the purpose of the complaint being to show that there was a disclosure rather than doing a close reading in this particular case. If there are no further questions,
Check.
we'll rest on its brief.
Thank you. Thank you both. Okay, the next case we have is case number 2023-0486, Commonwealth versus ROMILSON, FERREIRA.
Sorry, just getting over bronchitis second week, so I didn't want to start having a coughing fit.
Right.
Please the court, Joseph Magiacomo, on behalf of ROMILSON FERREIRA. You know, I had my notes here. I had my argument set up. As I'm sitting there, I'm always contemplating what's the most poignant way to start. In the phrase that permeates through this whole appeal is Mr. FERREIRA yelling, "You're not the police. You're not the police. You're trying to kill me. They're trying to kill me. Someone call the police." Throughout my brief, I've identified 3, possibly 4 arguments that all relate back to this statement. First and foremost, I would suggest to the court that the district court committed structural error in not allowing the continuance requested by defense counsel to obtain an expert. The effects of the cocaine were probative, relevant, and essential to negating knowledge and specific intent, constituting a complete defense to the charges. Now, I come before you, and for
Before you
those
move
that
on,
know...
Counsel, I wanted to ask you about the structural error. I mean, as the first authority you cite, I believe it's Washington, a federal case, and in that case, the issue was whether a defendant had the right to summons a witness, correct?
Correct.
And that's quite distinguishable from what we have here.
It is.
And what's the closest case you have on, in this Commonwealth or federally, of course, and which mirrors this case on standing for the proposition that the judge's decision constitutes structural error?
I would suggest, Justice Smith, that this may be the case, and I was going to get to that. There is a pattern. I come to you, for those who know me, I come to you both doing trial work and appellate work as private counsel under CPCS. And there is a pattern of conduct that is starting within the courts post-COVID. And I'm seeing it a lot with gun cases. All of a sudden, there's this mandate, and we're pushing gun cases. And there is no decision that references an abuse of discretion on the part of a judge. There is just this rule lingering out there that district court cases should be completed within a year. And I would suggest to the court that that rule, in this case, or relying on that rule, was an abuse of discretion under the circumstances. Now, I wholly recognize, and the trial judge pointed out, the numerous times that this case was on for status, for pretrial conference, for trial, for a motion. And that loops into the whole ineffective assistance, because even though counsel was privately retained, as you know, that doesn't negate counsel from applying for funds if in fact that was the issue, and we really don't know what the issue was, why we're a year into it, and there is no expert. But
that begs another question, is a motion for a new trial, there might have been an affidavit by an attorney as to some of these issues.
Well,
but we don't have that, correct?
We don't, for two reasons. Mr. FERREIRA was on a bracelet because of an ICE detainer, and his whereabouts at this time are unknown. Three reasons. His whereabouts at this time are unknown, which I would have needed Mr. FERREIRA to proceed with a new trial motion. There may be this...
Have you ever met him?
Please?
Have you ever met him?
I've had conversations with him telephonically.
Okay.
There is this misnomer that new trial motions can just be done by appellate counsel, and in fact that is not correct. There is a process, and the process has to be approved. We have to request permission.
You mean CPCS?
Right, from CPCS. And CPCS makes a determination as to whether there's a reasonable probability of success.
We're familiar with that.
Yeah.
What is your, which error do you say is structural? It's the denial of the continuance?
It's the denial of the continuance.
See, the problem I have with that is, I mean, maybe if we knew more, maybe if the lawyer had said more to the judge, but it's trials going on, and suddenly you say, I need a continuance. I think maybe an expert would be great here. And you can imagine the judge being like, yeah, well, I guess if you thought that, you should have hired one, but it's the day of the trial.
And that's based on this administrative rule that we want to push cases along, and we want to...
No, it's absolutely not. It's based on that you don't get to come in on the day of trial and seek a continuance for something that a reasonable lawyer would have done a year ago.
I would respect...
Can I just add, it's not an administrative rule. A defendant has a constitutional right to a speedy trial. So to the extent that there's what I think you referred to, a push in the district court to get cases tried within a reasonable time, isn't that because of the defendant's right?
First, with all due respect, Justice Rubin, I would disagree with you. Doing trial work with reference to that underlying statement. This case is a case where we were only 2 months over the 1 year. But I think what your statement does is your statement validates my ineffective of counsel claim.
I agree with that. I think that moves us to ineffective assistance. But that's not structural error because it has a prejudice prong.
Right. I would suggest to you that the judge has discretion to go over Rule 36. And Rule 36, I would suggest to you, Judge Vuono, is a baseline for the defendant. It is not a rule. It is not a
Sure, a defendant can
rule
ask for more time.
For the Commonwealth to exploit to their benefit. What prejudice would there have been with this case being 2 months over the 1 year that we like to see these tracked?
I just want to clarify. My point is that it seems to me that there is a reason for the bringing a case to trial within a year. It's not just an arbitrary administrative rule of the district court. That's the point I wanted to make. And I don't know if you agree with me or not. I'm not asking you to, but I
understand, but I would suggest a rule has to give way, for lack of a better phrase, to a right. And there were numerous violations of his right. If you don't agree with structural error, that is fine. But again, Judge Rubin basically made my point with the ineffective assistance.
Okay,
this was a year.
But my question then is this, the prejudice prong.
What was his defense?
Well, don't you need to have, again, a motion for new trial? And I heard what you said about the difficulty of doing it. Don't you have to present an expert to get a new trial who would say, yes, I would have said he's psychotic or whatever, because otherwise one could imagine, I'm not saying this is the case at all, but one could imagine that you couldn't find an expert because this isn't an ordinary kind of cocaine response. Maybe every expert would say, well, that seems like, I don't know, what it is. You know what I mean? I don't know.
I understand that, but the ineffective assistance of counsel is not based on whether he could have or not. The ineffective assistance of counsel, the prejudice prong, is based on he did not within that 14-month period. And he states it. It's in the record.
I agree he didn't do it, and I'm assuming here that it fell below what we would expect of an ordinary lawyer. Right. So but then it also has to deny him a substantial ground of defense, and without some expert saying, yeah, of course I would have testified that way. How do we know? I mean, maybe every expert you go to will say, like, oh, that's not drugs or mental illness. You see what I mean? I don't know what it is.
If these were general intent crimes, I would be more inclined to agree with you. But these were specific intent crimes. And when you couple the Commonwealth's burden of proving specific intent with Mr. Ferreira's statements that came in through the Commonwealth's witness, I would suggest to the court that in and of itself is enough to surmount the prejudice burden. And he is stating, you're not police, you're not police, you're trying to kill me, they're trying to kill me. Someone called the police. These are uniformed officers. The second uniformed officer pulls up in a marked unit.
Aren't you essentially saying then that the trier of fact was aware of this evidence that would negate specific intent? It might have supported the defense with an expert. We don't know, as Justice Rubin points out. We don't know because we don't have an affidavit or a motion for new trial. But the fact that your client was in a very difficult situation there was definitely evidence of that.
And here is the issue with that. The trier of fact was the judge, and I'm sure you read the transcript. To me, it seemed like the trial judge was appalled more by the conduct. And when the trial judge does raise the issue, well, you're saying this is a complete defense, which it is. I think we would all agree. It is the inability to form knowledge and the inability to form specific intent, not a mere striking. You have to have the specific intent, which means you have to have knowledge that he is a police officer. Defense counsel says no, it is not a complete defense. Now, maybe the judge didn't know it's not a complete defense. With all due respect, we educate each other every day of the week. We forget things, we don't know things. It's impossible, unless we have an AI robot up here, to know every case law, the aspect of every case law. But I would suggest to you there was enough on the record in and of itself to show prejudice with reference to the IAC. Now, when you finally, I know I'm running out of time, again, there was not enough evidence in and of itself under a sufficiency standard for either of these charges.
Well, if you don't believe him, if you think he's faking it, then there's plenty of evidence, right?
But there was no evidence of that was brought in. The officer, in and of himself, Commonwealth's officer testified, listen, there was something going on. His pupils indicated there was something going on. His behavior indicated there was something going on. His statements indicated there was something going on. There was no evidence presented to refute what the officer believed was a central nervous system issue, and that was his testimony. This was a central nervous system issue. His pupils were pinpoint. This is an officer with years of experience in picking up cues like that, and I think we can all agree with that. I keep bringing it back to me because it's just a relevant point. I was an officer in my 20s in Miami. You learn real fast when someone's on something. It's over time, over repetition, you're able to say, oh, you look for those cues. So you have an officer saying that in fact, this was going on, which again, I would suggest to you goes to the underlying issue of a sufficiency of the evidence as to whether he was able to form the requisite intent for the assault and battery, and whether he even had knowledge that a uniformed officer was in fact an officer. I don't think we need an expert for that. His actions in and of itself, I would suggest, Justice Rubin, I would suggest it could be inferred that he did not believe.
Just a moment, we have one more question from the panel.
We focused, counsel, a bit on the prejudice prong or aspect of the ineffective, but I'm not quite convinced the record establishes counsel's performance was below the bar. As we have a record where counsel told his client to meet an expert, and the client didn't do it in time, essentially, is an inference we can draw from that. So what else is counsel supposed to do?
Again, apply for funds.
He didn't need funds.
Apply for funds.
He was retained, and I believe the record was clear he wasn't looking for funds.
Right. But you're asking what he should have done. If this was me trying it, I would have asked for a motion for funds for an expert. I would have retained an expert, and I would have gotten the client in there, and I would have said, you need to be examined. I think, I'm out of time, but to answer your question, I believe we can't lower the bar where trial counsel is hired and then everything gets left to a defendant that may not have an understanding of how important this aspect, in this case, may be to his defense. That's why we go to law school.
Yeah.
Thank you.
Thank you.
Good morning. May it please the court, Rose Ellen Elcoury for the Commonwealth. The Commonwealth contends that there was no error by the judge or the defendant's trial counsel that warrants reversal of the defendant's convictions for assault and battery on a police officer, resisting arrest, and disorderly conduct. Further, the evidence submitted by the Commonwealth at trial was more than sufficient to support these convictions, specifically the assault and battery on a police officer and resisting arrest, which the defendant now challenges on appeal. Beginning with discussion of the judge's denial of the motion to continue. As was stated during the defendant's argument here before the court, denial of a motion for continuance is judged based on an abuse of discretion standard. This was not a structural error. This should be evaluated under the abuse of discretion. And this judge was well within her rights to deny that motion for a continuance. The right to call witnesses is not absolute, and the judge is within her rights to deny the motion for a continuance under Rule 10 of the Mass Rules of Criminal Procedure.
Counsel, you cite Gilchrist as supporting your proposition that it was within the judge's discretion was an error, correct? Commonwealth v. I think it's Gilchrist.
I believe I do, yes, Your Honor.
And there are some facts in Gilchrist which are helpful to you, in that it was the same day of a plea, and the defendant wanted to call an expert as to the voluntariness of the effect a drug would have had that he's claiming ingested before the plea.
Yes.
And the court again found it was an error for that judge to not grant the continuance. But in that case, it's also established that another expert had testified, or a doctor from the jail had provided information.
Yes.
The judge also said he had information about the effects of that certain drug on people generally.
He did.
So that really distinguishes that case from ours, doesn't it?
In that respect, that factual respect, yes. But for the overlying principle, it remains the same. The judge has discretion to deny a motion for continuance even where that motion is based on a request for more time to call an expert witness. It is factually distinct, but I would argue that the principle should carry over into this case. The defendant was informed by his counsel of the person, the doctor that he had spoken to, was told that he should set up an appointment with that doctor. The defendant did so, but the defendant, not being aware enough of the timeline of his own trial, did not do that in a timely manner, and the fault, if there is a fault, for the absence of the expert rests on the defendant in that case. It's not, his lawyer appeared on the day of trial. He clearly knew that the case was scheduled for trial that day. It was the defendant who was unclear about the timeline. And
So counsel argued the judge was wed to a one-year rule, which I'm not sure the record supports, but the judge was balancing something. And what would the prejudice have been to the defendant? The defendant was not in custody. The Commonwealth wasn't seeking to go to trial that day. At least they weren't vigorously advocating for it. So what was the judge considering, do you believe? What can you infer from the record?
I think she was considering the fact that, and I believe she stated, there had been 5 continuances, not in the case, but of the trial date. The trial was originally scheduled, I believe, for May 12th of that year, and it was ultimately held on December 20th. This was not a complex case. Despite sort of the discussion around whether or not the defendant was affected by a drug at the time of the incident, the issues were pretty straightforward. The elements of these cases are pretty straightforward. The Commonwealth had 2 witnesses. They were the police officers. They testified to what happened. The defendant testified on his own behalf. He wanted to call an expert to sort of bolster his statement that he was affected by drugs or alcohol or lack of sleep on that day, but there was no even affidavit from an expert saying that this is my realm of expertise based on the facts that have been told to me by defense counsel during our conversations. It seems likely that, to give the court even an idea of what an expert would testify to. So in this case, I think it was just the defendant had requested continuances of the trial date before and no action had been taken, and the judge looking at that record had no reason to believe that there would be action taken before a new trial date, and she opted to hold the trial, and I think it was not an abuse of discretion for her to make that decision.
Can I ask you a question? I guess it's about your brother's last point. Do you agree that if what the defendant was screaming while the police were holding him down. These aren't the police, someone call the police. That if that is an actual reflection of his internal state of mind, if he really thinks that, do you agree that he couldn't be found guilty of either crime because he wouldn't have knowledge they were the police and therefore wouldn't know that he was being lawfully arrested?
I think that given that the defendant stated in his testimony that he had believed that they were police up until a certain point.
Yes, when the second officer arrived, somehow that, I mean, he was a little suspicious of it when he's, if you believe his testimony, a little suspicious of it behind the counter. He thinks he's calling the dispatcher or something on his phone to like check if this is the guy they sent because it seemed too fast or something because the guy had said, so he's already suspicious. And then he thinks irrationally, of course, that somehow this second person confirms it. My question is, if he actually thought these aren't the police, I wish someone would call the police, could he be convicted of either of these crimes?
So I hate to rely on an unpublished case, but I believe page 49 of the Commonwealth's brief, I do provide a copy of Commonwealth versus Blair, which is a sort of similar fact pattern. In that case, though, the defendant was drunk and was presently drunk, hadn't ingested, a substance hours before, and then, begun to act irrationally about 8 hours later. The court held in that case that it was the issue of the general intent to commit an assault and battery coupled with the knowledge of the officer's status. Now, I understand that you're saying if he sincerely did not believe that they were police, that he should not, he can't be found guilty of assault and battery on a police officer.
Do you agree with that? That if he
knowledge that an individual is a police officer acting within the scope of their duties is an element of the crime. So
if he truly believed this wasn't a police officer,
if the judge
and
had
he'd be not
credited
guilty,
his
what is the
statements,
evidence that he didn't truly believe that while he's lying on the ground?
it's his statements. His statements are the only evidence.
His statement is that previously he had thought they were the police. How does that undermine that he no longer thought they were the police?
Right. In defense's argument, I believe he opened by referencing the statements made by the defendant. And on page 39 of my brief, I do discuss that he's referencing statements that were made by the defendant during the defendant's testimony. So the evidence to indicate that the defendant didn't believe that these were police officers came from the defendant, and that becomes an issue of credibility. So for sufficiency of the evidence,
What's the affirmative evidence? Let's say the judge doesn't look at that. What's the affirmative evidence? The officer also testified, I think, that he screamed at least part of this. Somebody called the police, I think. I don't remember.
he did testify that he yelled something to that effect. I don't remember the exact phrase.
But something that indicated he didn't think he was, obviously it could have been a lie or a...
It also could have been, taken in the context if he believed that he stated the officer threw him to the ground. If he believed that an officer was handling him too violently, he might have wanted other police there, and I apologize, I've lost the track of your question.
No, I'm still on, if he subjectively believed it, is there evidence that he didn't subjectively believe it? And I'm just, given that the officer looks at him, he has pinpoint pupils. I don't know what that means because there's no expert. To me, everyone's talking about cocaine, and maybe cocaine has something to do with it. I'm not familiar enough with, 5 hours after taking cocaine, you think people are coming to kill you. I don't know how people react to drugs. It seems more like he's mentally ill to me than that it's a drug-related thing, and no one, certainly the lawyer didn't say anything, but the defense lawyer didn't mention that.
There was a competency evaluation, and the defendant was found competent.
Was he found that he was... Was there a finding that he was competent on the day it happened? Or is it
It-
just a finding he's competent for trial?
The evaluation was his competency for trial, and I believe it
Okay,
did
so
occur
that
something
doesn't
like.
tell us anything, right, about that day.
But if there was an ongoing mental illness, one would hope that that would have been picked up in the screening for competency.
I know nothing, why, I don't know, that sounds wrong to me.
Okay.
Right, I mean, someone with bipolar disorder, for example, might be in a manic phase, and then when they're examined, they might be not. I mean, mental illness isn't always,
Well, I mean, without getting into the specifics of a mental illness, a competency evaluation was performed by a trained medical professional. So we can't say one way or another whether or not they picked up on any other issues. It's not in the record before the court.
is the competency evaluation in the record?
I'm sorry?
Do we have that evaluation at all, or it's not in our record?
I did not have a copy of it. I didn't include it in my supplemental record appendix.
The docket actually reflects he was sent for competency and responsibility,
I believe so.
but the docket only concludes he was found competent. It doesn't weigh in on responsibility, which is, I believe, what Justice Rubin is asking you.
Right. I don't think it indicates that there was a finding one way or another. Certainly, if there had been a finding of no criminal responsibility, the defendant, his attorney indicated that he had originally intended to pursue a lack of criminal responsibility as a potential defense and ultimately determined that was not viable. And that is in the record. So, assuming that there are no further questions.
Question?
I don't, but.
I'm going to check. Yes?
About the attorney's role here, do you
Yes.
believe it was, can you speak to whether it was adequate, whether it was ineffective?
Whether or not the attorney did everything he could to ensure that the defendant had an expert available at trial, even assuming that he didn't, and that his actions fell below the standard in that regard, it definitely did not deprive the defendant of an available ground of defense. The information, and the judge even said in rendering her verdict, she didn't question that there was, quote, something going on that day. She just didn't find that it negated the requisite knowledge to find him guilty of the assault and battery on a police officer. So, for all.
Well, I think that's the issue, though. I think what they'd say is if there had been an expert, maybe she would have found differently.
Possibly, but without even an offer of proof, there was, as previously discussed, no real, and honestly, no reason to believe that another extension of time would have brought an expert before the court. I think those two things play off each other, but I don't think that they are the same. Like, I don't think they're the same. The denial of the motion to continue is not, the ineffectiveness of.
Dealing with ineffective here for the first time is obviously not the desirable way, and there was no motion in the trial court. But you contend that the issue is not indisputable from the record, I think in a footnote, although you do argue the merits of it. But do you believe now that it's indisputable, the issue of?
No, I maintain that it's not indisputable. We don't have an affidavit from defense counsel, at least attempting to explain why he made the decisions he did. So without that, I feel like this is not clear. And furthermore, we don't have any information to what an expert would have testified to. So that's another element of that is not before this court and makes it difficult to rule on ineffectiveness.
Okay.
All right. Seeing as there don't appear to be any further questions, the Commonwealth will rest on its
I've
brief.
confirmed with both members of the panel that they have no further questions, and so you may rest on your brief. Thank you both very much. Okay, we're going to take a brief recess, and so the courtroom can be ready for our third case. And once we hear that the courtroom is ready, we'll come back on and hear that case.
Mr. Carter.
Recess.